another exciting video for you, another outside video. We're here in Florida this week, and the weather is up and down. I shouldn't complain. I know there's snow and other ground, but I'm in the shade. So this today is what to do when sued by a debt collector. The reason why I'm doing this video today. Remember, this is single jeopardy. This is jeopardy. This is single jeopardy. So look for my jeopardy forms attached to KillDebt.com. So we're doing a live question and answer on March 21st, 2025 at 5 p.m. where you can ask me any debt-related defense question. And what we've done, we've set up a sign-up ability. So contact Natalie with your questions ahead of time if you want to ask a question, and I can better answer your question if I know what's coming. I'm very good in some areas where I've got a stored data of 30 years there, but maybe heads up I can give you an even better answer, because I hate doing stuff than walking away and going, oh, I could have said. So send me your email questions. I have one today that this video is based upon. We got an email from someone based upon this Q&A that's coming up that says, I've just been served by Citibank for a Home Depot credit card that I stopped paying. There's a court date of May 7th, 2025. I don't know what to do or how to proceed. I called numerous attorneys, but they can't help because they only do bankruptcy. So remember that last part about bankruptcy. If I may digress a second, people write, and I invite comments to criticize me, not necessarily criticize me, but criticize for the better. It's called constructive criticism, and I want that. I don't have an ego about making the membership site better for you. So someone wrote, let's put it up, Shazam, and I pinned it, meaning I just learned that means you go right to the top of all the comments, so I'm not afraid of it. And it says, about my video yesterday, the governing law provision video, absolute gibberish info if you're not an attorney. So I listened to that and I wrote back, watch again. And there's a reason why I said that. And then a good friend that's been with me from day one, when the membership site was, we had these launch prices of $49. Now it's $119 for everything a month. And he stayed there. The site is helping him. So he wrote, and I listened, and he's made comments in the past that I've listened to and try to fix stuff, because I want to make it so it's accessible and not perfect, but accessible and available. So he wrote, I don't understand the concept you're sharing regarding that governing law. My understanding of what you're presenting is that the governing law would dictate that the civil court action must be located in a state mentioning the governing law clause if that was Utah, and I'm located in Ohio. I don't understand how you're arriving at the theory that governing law equals filing a lawsuit in some other state. I didn't go to law school, so maybe that's just not my understanding. The governing law concept of the governing law concept you're presenting. So that's the same as that other gentleman said. And I wrote back the compromise, which when you get at the end of arguing with the court about what law you want, I say you make a compromise. If the governing law means there's a better chance for you on the statute of limitations, for example, get it into the governing law that the contract says you're really supposed to be in. But the compromise is yours to make. And then the gentleman wrote back, okay, this explanation is resonating more. Based upon this explanation, it does seem that you're saying that I have to physically transport myself to Utah, but I would simply avail myself of the Utah laws as applicable to the lawsuit. Yes. So the substantive law is applied in the law that you're in. The procedural law is what the judge of the court that you're in uses to have you navigate using the law of Utah. I want that because it causes problems to the other side. It is also placing you on the same level of expertise as the other side, because you're both sort of ignorant of Utah law, and then you're going to do more work because it's your case. He's just going, or she is going to look at it and go, it's one of 150,000 cases I have, and you're going to beat them that way, knowing Utah better. And the judge will be more receptive to your arguments. You're evening the playing field in some respects. So that worked out for him, but it didn't work out for me as it sat with me, and I worried that there is, as that gentleman said, I'm just full of gibberish. So I watched my own videos to see what I got to fix, and I asked our super webmaster, Natalie, who's working on that, I'm not getting to what I'm supposed to be doing, but the vaults form, and she said, and let's put it up what Natalie said, ma'am, I don't have a clue what you're talking about. You seemed really excited about something that appears really boring. Did you drink coffee or were you on something when you did that video? So I thought about that and I thought, well, maybe I have to slow down a bit. But what I found is in one day, we surpassed our normal amount of both subscribers and viewers that we will get in a 24-hour. I started to learn to look at these numbers to do things better. And that wasn't my intent in doing this channel, but the numbers were higher for this than I normally would get. And in a way, that's a credit to you. I don't like to talk down to anybody. I certainly don't like to be talked down, so I'm just going to be me. And I don't mean to be talking gibberish, but I get it. And I will reveal something to you that at certain points in my day, even Natalie doesn't want to deal with me because I'm, if you will, high as a kite, meaning not medical marijuana or anything, but I have real bad ADHD and attention focus. Especially when you get older, this happens. And I got diagnosed at 60. And I take this one pill and it's just opened the world for me. So I see things a million times faster than I used to. And so you may see that verbally, the brain vomiting. So I apologize for that. But I hope you'll take another look at the video and see that I'm trying to present stuff for you to help you in these cases. So back to our gentleman's question and the reason why we're doing this video. It's all good, it's all positive. Comments like that, whatever side of the V or whatever you believe in, because I believe only in one thing, and that's America and the US Constitution. And everything it presents you is enforcing what the Constitution has granted us. Nobody can step on anybody's rights, and I'm presenting you your rights. Most people, as I'm going to show you, they're being sued, and it's crippling. I'll be the first to admit that I had my own financial problems where I was fighting off lawyers and law firms. So I've been there, done that. I still, to this day, I get a little weird when someone knocks on my door. And during campaign season, people are knocking on your door, and I still get that little, ugh, is it a debt collector or a lawsuit feeling? And that was 30 years ago. But I've been there, done that. So the question again is, let's put it up again. I've just been served by Citibank for a Home Depot credit card that I stopped paying. There's a court date coming up. I don't know what to do about it or how to proceed. I called numerous attorneys, but they can't help because they only do bankruptcy. I know what that person is talking about. What happens is, and I see that, I look at a lot of cases that I will help people with where they get several letters in the mail from attorneys, whether it's for tickets, they got a ticket, or they're getting sued. And most of the letters are from bankruptcy attorneys telling people you got to go into bankruptcy. So that's, I think, what he or she is saying. And we're going to talk about that very briefly. Don't do bankruptcy unless you're just so weighed down with debt and you can't get out of it. Even then, if you can piecemeal a couple of those debts by defending yourself, now the amount you owe shrinks, and it's in the long run better for you not to do bankruptcy. But bankruptcy is a very good option as far as peace of mind, just getting that stuff done and a fresh start. But not unless you've got a lot of crushing debt and you don't worry about the 7-year problem that bankruptcy can cause. So I started off by talking about jeopardy, and one of the things that happens and why people call me is they get these letters from bankruptcy attorneys saying, you're being sued and here's your case number and you owe this, and then they freak out. So they will then go to the website of the court that they're being sued out of, and using that case number, I'd give you this advice. So if you get one of those letters or you find out you're being sued, before you are in jeopardy. You've heard the expression double jeopardy. So you can be aware of a lawsuit, you can see a lawsuit online, or unless you are served, you are not in jeopardy. So you can't be faulted or defaulted. It's interesting, the word default you can't spell it without the word fault. You can't be faulted for not answering unless you receive the lawsuit. And you can only receive that one of a couple of ways. Checking online to see why or how you're being sued is not one of those ways. So you can even go to court and go, I think I'm being sued. Can I see the court file? Because it's public records. You can look at the lawsuit, rub it all over you, and take it with you. You have not been served until someone properly serves you under the court rules of your state. So you are not in jeopardy. So, number one, editor, if you receive an attorney letter, check the court docket with the case number of your name, check out what was filed, and get yourself informed. Remember, going to court and printing the lawsuit is not service. So it is an attitude adjustment. I said to you earlier about my own situation, so I've been there. I understand being sued is scary. I still suffer from that, as I said, but also now with these videos and things, I'm starting to get these letters from attorneys representing some of the people I'm yelling about, saying, blah, 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 blah. And so now I'm getting to start this, is that a lawsuit? I'm in better shape now, but I wasn't, and that resurrects how you all feel with a lawsuit. So change your attitude. Meaning, I'm not telling you what to do, but there is you can turn this into a positive, and you can take action before you're in jeopardy. You're only in jeopardy when you're served with the lawsuit. Like the person that raised this question, they have been served, they're now in jeopardy. But generally, and that's the reason why I focus on that bankruptcy part of that question, because that's usually how you find out you're being sued these days. It's a good thing because now you've got a head start against all this. Whereas if you're being immediately sued, you've only got 20 days to do something about it. But even if you do, here's the advice I'm going to give you. On KillDebt.com, there are going to be letters attached to this video, or in Natalie's document vault, that enable you to take charge before you have to answer the lawsuit and answer this question. So here are the letters that I'm going to attach. There's going to be some new ones. I'm always developing letters for you that you can use to buttress or support your defense, or make them, and this is a good shot at them before you have to answer, and you can already make them show their proof. And sometimes if you do these letters right, you'll see what I'm about to tell you, they will have one hand saying, this is the proof, and the lawyer who's not paying attention, he just gives whatever in the lawsuit. It will say something different. Because you did that work before you actually have to answer the lawsuit, you just created a new defense for yourself. You messed them up. It's all about being an educated consumer, right? So here's the following letters that I've created for you for this type of situation, whether you receive the bankruptcy letter saying you're being sued, we'd like to help you, or like this person said, I've been sued, this is what's going on. They're both looked upon in my head as a positive. Don't just think negative, crushing. Have your little, as I always say, have your 5-minute pity party, then come out swinging. And this is how we're going to do it. Let's take a look. So I'm going to put up all the letters I'm going to attach for this video. Shazam. The securitization letter. So if you're being sued like this person was by Citibank or Discover Bank or Amex or Cap One, name your creditor, Wells Fargo, whoever it is, have a security letter, securitization letter. Most, if not all, creditors are sending their or your debt and the right to receive future payments and your balance to increase to securitize trust. Origination. They are the originator. That's why they call it the original creditor. Why don't they just call it the creditor? Because you're only a creditor. Whoever gets it next is either a debt collector or current creditor, if you will. But so they're called original creditor because they originate the debt and then they send it to a depositor securitized trust that they've set up. Like Citibank, in this case, has a Citigroup trust. And that drops in. The trust sends money back to Citibank for buying it. They own it. And the only ownership of the original creditor is the right to receive payments, which go not to Citibank, they go to the trust because they own it. So they are nothing more than debt collectors or servicers of the debt. So Citibank, you send them a securitization, you send it to Citibank, who isn't in communication with the law firm that's suing you, and you find out where and how and where the debt is. The letter itself is explanatory, self-explanatory, telling you, and if you get this stuff from them, it's going to counteract what the schlocky attorney lawsuit that's coming your way, that's the same lawsuit that comes your way 1,000 times. It has no care. It's a great defense. So a creditor validation letter. Again, most debts are securitized, so the creditor is nothing more than a debt collector. So send a creditor validation letter saying, hey, what's up? You're a debt collector. Validate the debt. You're going to get a response. And it may be something that you can use against the debt collector or the debt collector law firm. So here's a new letter I just created, okay? Oh, by the way, that last one, I'm going to show you a summons today that has, we are debt collectors. Anything you say will be used for that purpose. Totally illegal to do that. There are millions, literally, of those in some of the states I practice. We are debt collectors. It's not required to be on the summons. It's there specifically to scare you. But as I've said in the past, it also kills the case for the plaintiff creditor, who now is looked upon as a debt collector. So this new letter I just created, and it was from a comment. It's something, when I was doing a video, I'm like, hey, wait a minute. And then a commenter got what I was saying and said, yeah, go in on the credit reports, because if the debt's securitized, the person that's putting something on your debt doesn't have the right to collect what is owed to the securitized trust. So I created a new securitization FCRA dispute letter, and you're sending it to the credit bureaus and, let's say in this case, Citibank, to say, why is that on my credit report? This debt has been securitized. Where is the securitization evidence? Why do you owe that much? It is false. Remember, the rule in FCRA trade lines, a trade line is what's put on your credit when either someone's pulled your credit or put something on your credit, is it must be true and or accurate. So you have a right to dispute if anything on there is inaccurate or not true on there, meaning your credit report, and say, hey, fix, delete, or frankly confirm. That's a response to, and if it's incorrect and you've got enough goods, you can sue them, and it's another way to get your way with them in your defense of your creditor lawsuit. So you can say, I sent you a dispute letter, you failed to honor it, or you improperly put something on that's not true. You can defend and counterclaim under the FCRA now, not just the FDCPA. And also, if you're in a good state, for example, one of them is Florida, FCCPA, and the FCRA, you've got a ton of ways that you've discovered and documented and researched when you eventually hit them back, or you can present that in your settlement of attempt before you have to get down and dirty with this. So also, a validation letter should be sent to every debt buyer and its attorney, and a securitization letter to, let's say you have, for example, again, I always use this Velocity. If Velocity says they own the debt, They provide a chain of title showing it went into a securitized trust. It was purchased from Upstate. It was purchased from FinTech. It was FinWise. Send those guys letters. And also, if it's an Upstate type of thing, send them the registry letter, because all their loan agreements say, if you don't believe we own this debt, just send us a letter and we'll show you proof. So that'll be attached to my lawsuit, this video too. So why not? I'm going to create a lawsuit letter for you. So let's say you've learned you're being sued, or you have been sued. Send a letter to the law firm, and I will produce a skeleton of the letter, and you can add your bones and ligaments to immediately find out why they're doing what they're doing. Any response is a good response, because sometimes they're going to make mistakes, and that'll be good for you down the road. I say that because a lot of times this is the normal response. Someone finds out they're being sued, they immediately call the debt collector and go, hey, what's going on? They admit stuff they shouldn't admit. So I want that letter, as you will see the letter, it will be shaped in the form of a settlement approach. Anything that's done in settlement discussions is not allowed to come into a lawsuit. So you can ask for what you want in a settlement discussion. It can't be held against you, otherwise no one would be able to settle things. So what we're going to do today is tell you, once you, in answer to that person's question, because they have been sued, set up a calendar, and you've got to remember your default date. So let's say you were served on March 1st. Your default date, let's say in Florida, which is 20 days, is the 20th. You're going to be defaulted on the 21st. So set up your default date of March 18th. You got served March 1st, March 18th. That's your drop dead hard date, right? Up until that point, I'm going to show you what to do to try to settle this maybe, or at least set yourself up for when you have to answer the lawsuit. So let me give you a type of summons that you're going to see in lawsuits. Shazam. And that's a Florida lawsuit. There's 2 pages there. Excuse me, it's a Florida summons. But this is really good. The state of Florida is doing a good job here. Look at the second page. It starts with important. A lawsuit's being filed against you. Let's just emphasize that. Shazam. This is the best summons I've seen in a while. It says a lawsuit's been filed against you. You have 20 days after the summons is served to file a written response. That's really important, because a lot of clients will come to me saying, I've been defaulted. I go, well, what did you do in response? In a nice way. They go, I called them and told them I disputed. You have to file a written response in the court and send a copy to the other side. They must be placed on notice of your written response. So that's a nice thing they've done there. And they say a phone call will not protect you. They're right. Don't call the court and say I dispute and then get pissed because the court didn't tell you anything. The court doesn't see anything in writing. It won't tell you what's going on. Your written response, including the case number, must be filed if you want the court to hear your side of the case. So that's a really good summons. Here's one from Michigan, and that is okay. But by the way, in Florida, if you've been served a lawsuit, it's only coming one way, meaning whether they serve you personally or send it in the mail, you still only have 20 days. Whereas in Michigan, let's put up a summons in Michigan, just that page, Shazam. If you go to the bottom, let's emphasize the words after summons. You'll see they tell you specifically you have 21 days of receiving the summons and a copy to file a written answer in bold and serve a copy on the other party and serve it to the court. 28 days if you're served by mail. So Michigan's a little bit more friendly in that regard. They say if you get served by mail, you get an extra 7 days. Or if you're outside of Michigan and you're served, you get an extra 7 days. So that'll be on your summons. If there's no dispute there, they will tell you when and how to answer. Follow that. Get that on your calendar when your answer is due. Then put it 2 days before it's due. So if you've done everything you can, it just isn't getting settled, you got 2 days to overnight or personally go answer. But get that thing time stamped before the default date. Yeah, as a side note, with the summons up there, they're saying this is a communication from a debt collector. We're attempting to collect the debt, and any information obtained will be used for that purpose. That's not allowed. That's specifically not allowed under the FDCPA 1692 E11. 15 USC 1692 E11 says you can do whatever you want with the communication, you just can't put it on a legal pleading, a legal document. So I'm going to give you now 12 things to do. Yeah, good. I'm going to give you tasks. But please follow them. And I'll attach my show notes so you can go take a look. The first is calendar, as I said, a hard and fast date for default. It's called your default date. If nothing gets done before the default date, all bets are off. So let's say, and this happens, you communicate with the debt collector and you're going back and forth and it looks like you're working out, but they keep stringing along, or there's a delay, it's a weekend, it's a 3-day weekend. That stuff is purposeful on their part. They know exactly how they can settle the case. They don't need to go back to their boss like it's a freaking, you're buying a car and they have to go ask the general manager if he approves of the amount you want to pay. It's all right there in front of her. Headset Harriet. She knows exactly how she can settle. She needs to call her boss 5 minutes, email, hello. So they will purposely delay stuff. Watch out for that. Once you have that default date and you don't get the case settled. By the way, if you do settle it, in writing with a dismissal, because they set these things up, all these ways to get you to the default date, not answer, then they sneak in and default you for the whole shamil. So send the right letters I'm presenting you with this video before sending any contact of your own. So if you're going to call the debt collector, don't do it until you sent those letters. You may want to wait a couple of days if you've got a cushion, so that they receive these letters if you're sending it to them, so they know you're serious, they know you're educated. And don't let anybody tell you differently. When a debt collector receives a dispute letter or a validation letter, you just made their job so much harder. They're not even allowed to talk to you again until they've properly validated under 15 USC 1692 G. It's actually 1692 GB, which says thou shalt not contact the debtor until a validation response has been sent back after they see the validation request in writing. Everything's got to be in writing, not only because it's the law, but remember what I say, keep a paper trail, registered by mail. So anything you're sending them, send it certified, return receipt requested, copy of the letter, copy of the green card when it comes back. If you contact the law firm to work out a deal, this is number 3, always keep saying settlement, settlement. I'm doing this to settle, because they will want to use your admitting, they're going to admit the debt within the court. So they can't do it under the guise of settlement discussions. You have that calendar date. If this stuff doesn't get worked out by the date, all bets are off. You can still keep talking and working it out, but they are trying to get you to miss the calendar date by delaying you. Oh, that's a good offer. I'll get right back to you, and you wait a couple of days. I've had clients call me all the time saying, we had a deal, and then they defaulted me. You didn't. You had a deal. But until something is signed on the line that is dotted, you don't have a deal. Until the case is dismissed, you don't have a deal. So always be mindful of that calendar clock. Check your options for hiring an attorney. So if the negotiations are going, at the same time, be looking for an attorney. Always be thinking one step ahead, all right? Remember again, whenever you're talking to the other side, this is a settlement discussion. They will ask you, they'll go, hey, what is your name? What is your social? What is it? They'll make you feel like you can't engage in settlement discussions without paying a price, meaning give me the information I want and then we'll discuss settlement. Don't. Be hard, be respectful, but I will settle this with you on a debt I don't owe, I don't admit I owe, calling for the nuisance value, but I'm not going to give you this information. Either you want to work this out or you don't. So check your options at the same time for an attorney. Go to Google reviews. Advise the attorney of the work you've already done. You're selling the attorney on taking your case, even though it feels like you're sometimes people are like, I hope the attorney takes it and I'll pay whatever. Don't. You're just buying a product, okay? You got to find the best product for your needs. So Google him first, Google the reviews, but tell that attorney what work you've done. He or she may take your case more likely because he can see he's got an educated person that's done a lot of the work for him to enable his. We're always trying to do the best for our clients. I believe that. So if we can really do well, it's an ego thing, and that benefits you. So if you've already done the work, let he or she know, and they're more likely to take the case. When Googling for an attorney, FDCPA, put the letters, FDCPA, defense attorney in your state and your county against, and then either say the collector, the creditor, or debt buyer, and see what your local results are. Check out the reviews. You know how to freaking check out reviews. So when you're talking with the attorney, does he or she focus more on settling than winning the case? You're not going to win the case the way you want to without some hard work or the right attorney. But if I hear someone say I'm heading into the battle hoping to compromise, settle, I want them going into this to win and then compromising. Because if you go in winning, trying to win, the other side gets that, the compromise value is better for you. If you go in already with your, how do I say this? Well, without any strength, and you're always looking for a settlement, the thing that ends up settling for is going to be worse than if you're going in to win. You have to put them on their heels to get the deal you want. So don't take an attorney that's all about settling the case. You do want to settle it, but if that's their main focus, even if you talk to them, you have a piece of paper and you go, and you just check off how many times they mention settle, and you ask them, what are your chances of winning, and they keep pushing you back to settling, get out of that. If the attorney pushes you for arbitration, and you know what? Ask the attorney, how have you done in this case? Who do you know? How long have you been practicing against Citibank? Have you gone to trial? Do you know how to eliminate the debt? And then ask him or her what you know, possibly. Tell me about securitization, attorney. Tell me about what happens to the debt when it's first originated. Tell me how I validate. Tell me about the FDCPA. You're buying something when you're paying someone to represent you. They're not doing you a favor. That's your money. And there's a cost analysis there. Working the thing out myself or paying an attorney to work the thing out. Does it make sense, especially if it's only $4,000 or less? So if the attorney pushes arbitration, run. Don't walk, run. Arbitration's never good idea. Treat it like the plague. However, if all is lost and all you got is arbitration, let's say you owe $20,000 and it looks like you're going to get nailed because you just have nothing, something went wrong, they've got the goods on you. Arbitration at least will get you into paying less than you're going to be on the hook for if everything else has failed. And most arbitration agreements, especially in credit card agreements, you can immediately say, I think I want arbitration, because I get motions against me all the time to compel arbitration when I push too hard, even though they've litigated the case. And I'm not going to go into that as far as when you litigate the case too much, you waive the right to litigation. So bankruptcy is an option, but based on what I told you before, make it be so much debt that there's really no other option. Self-defense. Companies like KillDebt.com. I've done the work. I tried to do the best job for you. There's nothing like us. Doesn't mean I'm the best. I think we are. But I know other companies that do this. There's one attorney in Arizona that's doing a pretty good job. Although for some reason he's focusing on arbitration too much. But again, look for these companies that do what I do if you're going to self-defend. Meaning, and also that math analysis too. Is it worth it to pay $2,500 for an attorney on a $5,500 debt if you can work it out and get it settled down to $35 yourself? KillDebt.com is set up it's an advertising, to do just that if you're going to defend yourself. And you know the price, it's $119 a month, and you get the whole thing done for yourself with a ton of videos. And Natalie's vault form now. So education is key. So before you hire an attorney or something like KillDebt.com, get educated about all your options, the cost-benefit analysis. Is the attorney a good attorney? Is it a debt buy case? But do those letters that I just told you. That will put you in the best, most educated position. You will see that when you call the debt collector or company, it will pop up. Oops, we got a letter. We did it. They'll know they're dealing with someone they got to be careful with. All right. So the most important thing is to have the goal how you want it. I talked with a member yesterday, and they were having so much fun messing with the other side. We talked, and it was clear that they should settle the debt, and they were in great shape to settle it. They didn't want to. I go, you got a get out of jail card there. You can get out of this. Yeah, but, and I'll just say this, we've been reading your stuff and we've gone through so many services. This is fun now. I want to keep this going. Have goals. So I said specifically, what is your goal with this litigation? They failed to answer, meaning they weren't sure. They just wanted to keep pushing and beating up the other side. That's not a goal. Do your cost-benefit analysis. How much is it going to cost? You know, and also, how do I want it settled? Do I want it off my credit if possible? So have a good reason for fighting and for settling, but always try to win first. That settlement produced will be better than if you just go in trying to settle and compromise right from day one. As far as contacting the attorneys, I've done lots of videos on settling a debt. There's a debt collector in Michigan, a large one, that has a phone system that's really difficult to navigate, and then they say they'll call you back. They don't. That's eating up days. They know it's all purposeful, I think, to just get that up there, 21 days eaten up. So you finally get a hold of someone, you go, hey, I want to settle this. Oh, great, we'll get right back to you. 5 more days passes. You think you've got a deal. They kind of hint that you do. Boom, then they default you. So watch out for that. It's important you have hard dates. That 2-day date, that default date, if nothing happens to your liking and that date comes, answer the lawsuit. You've done all this beautiful work with the forms I'm going to tell you about. There's cheaper ways than me. I have ebooks for like $9.99. One is How to Write a Killer Answer. One is Mastering the Battle on ID Theft, How to Credit Dispute, and the other's Top 10 Judge Tips to Help with Your Court Appearance. You can get all 3 books for a certain price. Or you can go to gumroad.com I don't know if that's correct, dashboard, but Gumroad has a bunch of my books and videos, just specific videos, lower than I think what I'm charging on my membership side. But you don't get me, you don't get Natalie's Forms Vault, but it's all a cost-benefit analysis. You do your best job. So with this video, I'm going to quickly put this up. Shazam, KillDebt.com. I'm going to call them my Jeopardy forms. You're not in jeopardy until you've been served. I'm going to put up the securitization letter with the video, a creditor validation letter. For debt buyers and creditors, the new securitization FCRA letter. Why is the money owed to Citibank if they securitize the debt? Because the secured debt trust company, they are owed that amount of money too. How do you get double dip like that? Who do you owe the debt to? So dispute you owe the debt on the FCRA. It all adds up in your favor. At the very minimum, it shows you to be an educated consumer. Trust me, no debt collector likes a consumer with a brain. Trust me. When I talk to debt collector attorneys, and I've got some good friends in the industry, they shudder when they have to go with a person that knows what they're doing. Or They can't stand it when they lose against a consumer who's representing themselves. Oh, that makes them look bad. They go back to the office, they have to say, you lost? Or the judge is who they're in front of 1,000 times, in a couple of months, just went against them. How's that judge going to perceive them? And you, as an educated person, are going to bring up all the mistakes they made. So trust me, an educated defendant, an educated litigant is their worst nightmare. Use these letters. Attach these letters to your defense so the court can see all the work you're doing. Just asking them to prove, hey, why do I owe that debt to them? All right? And that securitization letter, the validation letter. Okay, I hope that helps. It's born out of a client or a person that's going to be going to our question and answer session. It's going to be live online March 21st, 5 p.m. I always do these, and they're an hour long. They always go longer than an hour. I suspect this is going to go a while based upon all the emails we're getting now. So get your questions in soon, but you can participate on that day, and I'll read your questions that comes in. I had a nice email that said, I'm attending, I'm not saying a thing, I'm just going to listen and learn. That's good too. And I like these things. I like the interaction. And as I was talking about earlier about my brain, it is off the charts right now. So get it before maybe I'm a bulb that's burning bright before it goes out at this age. So get it while I'm hot, man, and I'll give you the best I can. Thank you very much today. Bye-bye.